All humility to my noble lord, I am A.A. Usman for the judgment creditors applicant.
Any other appearance?
Yes, my lord. May my noble lord be pleased. E.C. Ike. My humble appearance. E.C. Ike, my lord.
E.C. what? Ike?
Yes, my lord. My humble appearance for the judgment debtor respondent, my lord.
Here's the ruling of the court. Court registrar, you can mute yourself. Everyone should mute yourself.
Okay.
Court registrar, you can off your video as well. The judgment creditors applicants by a post-judgment application filed on the 23rd of March, 2021, brought pursuant to the 49 Rule 3, Rules 3 and 6, Sub-Rules 10, 2 and 3 of the rules of this court. On the 17th of June, 2021, a ruling was delivered by this court on that application. The applicant's prayer 1 in the application was deemed to have succeeded only to the extent of the sum of 35,265,873 naira 47 kobo, while prayer 2 was discountenanced. However, the court on the 18th of October directed the judgment creditor applicants to address it on the propriety of granting an order for the execution of the unspecified sum in the judgment of 2015, consequent upon which learned counsel on their behalf filed a written address on the 1st of November 2021. The court, having considered the address on the 9th of November, delivered the ruling, setting aside its earlier order, and in place, pursuant to Order 49, Rule 6, Sub-Rules 1 and 3 of the rules of this court, ordered that a summons be served on the judgment debtor to appear in court within 7 days of the receipt of the order, and should file an affidavit clarifying the amount calculated by the judgment creditors applicant as their entitlements. On the 26th of November 2021, the judgment debtor filed a 16-paragraph counter affidavit deposed to by one Kingsley Amuchuaka, and attached to the affidavit are 3 exhibits. They equally filed a written submission. I've reduced that into the body of this ruling. On the 11th of January 2021, the applicants filed a written address in response to the judgment debtor's counter affidavit. Though belated, but same was regularized. Therein, counsel on behalf of the judgment creditors applicants adopted the same issues formulated by the judgment debtor. I have reduced that equally into the ruling. On the 24th of January 2022, the judgment debtor filed a reply on point of law to the judgment creditor's written address. I've reduced that also here. And on the 30th of January 2023, parties in this case adopted their respective addresses. Counsel on behalf of the judgment debtor equally adopted the reply on point of law. Both parties referred the court to different parts of the affidavit and the exhibit in support. The court, after hearing parties, adjourned the matter for ruling. The decision of the court. I've gone through the gamut of the processes filed and exchanged by parties in this case, and I am of the firm view that the following issues are germane for the determination of this ruling. Whether this court has jurisdiction to continue to entertain this action. 2, whether this court has the power to order the judgment debtor to clarify the entitlements of the judgment creditors. And 3, whether the judgment creditors applicants can succeed in the application to enforce the judgment of this court. On issue 1, it is the contention of the judgment debtor respondent, be it their counter affidavit and written address, filed on the 26th November 2021, pursuant to the court's ruling of 9th November 2021, that since the Court of Appeal is seized of this matter, this court has no jurisdiction to continue to hear this action. The pertinent question at this stage is, can it be said for sure and truly that the Court of Appeal is seized of a matter in view of the peculiar fact of this case? From the counter affidavit deposed to by one Kisley Amuchwaka, Esquire, particularly at paragraphs 4 to 11 thereof, and a perusal of exhibits 1, 2, and 3 thereof attached to the counter affidavit, the following facts emerge: that the judgment debtor respondent just took a step to get leave from the Court of Appeal to appeal the judgment of this court delivered since 20th of October 2015 by a motion filed at the Court of Appeal on the 10th of November 2016, more than a year after the said judgment, and which leave was granted to the judgment debtor on 27th of October 2017. The judgment debtor, after the said leave was granted, filed a notice of appeal before the Court of Appeal on 27th of October 2017, but failed to transmit the record of appeal for almost 2 years after it filed its notice of appeal. Consequently, it brought an application before the Court of Appeal for extension of time to transmit the record of appeal in motion number CA/A/1173/M 2019, filed on 17th February 2019. Let me pause at this stage to say that counsel in the affidavit sought to mislead this court. In paragraph 10 of the counter affidavit, where he sought to refer this court to Order 8, Rule 4, Sub-Rule 2 of the Court of Appeal Rules 2021, which obviously was not the extant rules of procedure when the judgment debtor's motion for regularization was filed before the Court of Appeal, to say that their record of appeal upon being regularized is deemed to have been transmitted within 90 days from 27th October 2017, when the notice of appeal was filed. It must be mentioned that as at the time the motion for regularization, together with the records compiled out of time, were received by the Court of Appeal in 2019, the extant rules of the court were the Court of Appeal Rules 2016, and not that of 2021, which counsel was referring the court to, or on deemed entry of appeal. It is obvious that the applicable rules will be the 2016 rules and not the 2021 rules under which counsel sought to mislead the court. I say so in view of the settled position of the law that as espoused by the Court of Appeal in the case of Stars Ministries Incorporated, alias Kingdom Stars Assembly versus Argu citation captured, the litigant only has the right to rely on the procedure prescribed for the time being for the hearing of this matter by the court. When the procedure is changed, the litigant must proceed according to the changed procedure. Thus, if a litigant is to take any procedural step, he must do so according to the rules and not according to the old rules, which were extant at the time of the filing of the action or appeal. It held further that, nevertheless, when a step had already been taken and completed in the past according to the old rules then applicable, a change of the rules will not affect what had been already done and dusted under the old rules. The court therein held that the transaction of transmission and receipt of a record of proceedings on 27th of April 2012 were governed by the Court of Appeal Rules 2011, which was the rules enforced when the record were transmitted, and not by the 2016 rules, which was the extant rules when the Court of Appeal was deciding the matter. The court rationalized this position while relying on the case of NDIC versus Akahao and Sons Company Limited citation captured, that by and large, procedural matters are governed by the rules of court. But unless an enactment is expressly stated to have retrospective effect, the general principle is that a law takes effect from the date it is made, or when it is expressed to take effect. In the instant case, the judgment debtor respondent in the counter affidavit is said to have transmitted and compiled records with the corresponding motion for regularization on 17th of February 2019, and as such, the process is already completed. Thus, the transaction and receipt of a record of proceedings will be governed by the rules applicable when the record were compiled and transmitted and when the motion was filed in 2019, and not under the 2021 rules, which came later. Besides, the application for extension of time for regularization of the records filed and transmitted out of time, filed in 2019, must have been brought pursuant to the 2019 rules and not pursuant to the 2021 rules, which counsel is now referring the court to. At any rate, it is a settled position of the law that the Court of Appeal becomes seized of an appeal when the appeal is entered, and an appeal is entered when the date the record of appeal is transmitted to the Court of Appeal. An appeal is entered on the day the record of appeal is transmitted to the Court of Appeal. See the case of Izu and others, and Ike and others citation captured. Dinya D and Anoda versus INEC and others citation provided. Uguche and Imba citation also captured. The above is supported by the Court of Appeal Rules 2016, the extant rules when the said record was compiled and transmitted out of time, and which presumably is the rules under which the application for regularization must have been brought, particularly at Order 4, Rules 10 and 11 thereof. Thus, where the appeal has been entered at the Court of Appeal to foreclose the possibility of parties agitating their matters at the lower and appellate court concurrently, the lower court would cease to have jurisdiction and total jurisdiction would vest in the Court of Appeal. It is therefore very clear that where appeal has not been entered at the appellate court, that appellate court will have no jurisdiction to entertain any applications concerning the appeal. In the case of Ogungulugbe and the state citation capture, the Court of Appeal held inter alia that an appeal is deemed entered only on due compilation and transmission of a record of appeal within time. The appeal in this case is not entered until the application for regularization of the records compiled and transmitted out of time is heard, and same is granted, because it is only then that the judgment debtor will be deemed to have compiled and transmitted the records. All I'm saying here is that until the Court of Appeal regularizes the records compiled and transmitted out of time, there's no record compiled and transmitted before the Court of Appeal today. I say so in view of the decision of the Court of Appeal in the case of NDIC and Anoda versus Sun and Paddy International Group, Nigeria Limited, and another citation provided, that the consequence of a record of appeal transmitted out of time without an order for extension of time is that there is no valid record to support the appeal. See also the case of Okole and others versus Ozoike and others citation provided. In effect, when a record is compiled and transmitted out of time, it is only where an order for extension of time / regularization has been made that there is a valid record received at the Court of Appeal. As such, until the deeming order is endorsed on the record, there is no record before the Court of Appeal. Besides, it is not automatic that once an application for extension of time is filed, same will be granted. The grant or refusal of same is discretionary. That is, it is at the discretion of the court. See on this, the case of LO, Yemos Nigeria Limited, and another Unity Bank PLC, citation provided. The judgment debtor respondent has not told this court what stage the application for regularization is before the Court of Appeal. As of today, it has not been stated that the Court of Appeal has regularized the record of appeal compiled, transmitted out of time, or that the application for regularization has even been fixed for hearing. It is thus clear from the exhibits and the counter affidavit relied on by the judgment debtor and the record of the court that the purported appeal has not been entered, as the judgment debtor has not regularized their record, which were compiled and transmitted out of time, as their said motion for regularization is still pending since 2019, and nothing has been done to it, the import of which is that the judgment debtor has abandoned it. In the same vein, there is nothing to show that the purported application for stay of execution of a judgment of this court delivered since 2015, filed by the judgment debtor, dated 12th of October 2021, and filed at the Court of Appeal on the 14th of October 2021, after the judgment creditors applicants brought this application for execution, has even been heard or granted by the Court of Appeal. Besides, the judgment debtor has not shown that the appeal has been properly entered at the Court of Appeal to totally divest this court of jurisdiction over this case. The law is of common that judgment creditor is entitled to the fruit of his judgment, and the court ought not to allow the antics of judgment debtor to deny the judgment creditors such. See the case of Afolabi and Judicial and another citation provided, First Bank and Yegwa and other citation captured, Fatoyinbo and others with Sadeyi and another citation equally provided. In my view, the judgment debtor by its disposition to the whole appeal process, as shown by its lack of seriousness, due diligence in compiling and transmitting record within the time given or stipulated, and how long it took it to even bring an application to regularize its record, compiled and transmitted out of time, is only trying to deny the judgment creditors the fruits of their judgment through the instrumentality of the law. In view of all reasons supra, I am of the view that this court is still seized with jurisdiction over this application. Issue 1 is thus resolved against the judgment debtor respondent. As regards issue 2, the judgment debtor has contended that this court has no jurisdiction to make the order it made in its ruling of 9th November 2021 that it should come forward and give evidence of what the claimants are entitled to by the judgment of 20th of October 2015, which did not state the specific sums, but merely declared rights in favor of the judgment creditors, and that making the said order such amounts to reviewing the earlier decision. It is a settled position of our law that in the absence of statutory authority or nullity, one judge has no power to set aside or vary or review the order of another judge of concurrent and coordinate jurisdiction. See the case of Azu and Union Bank of Nigeria citation provided, the case of Cole and Jibono and others citation provided, with Bush Limited and Dale Power System PLC citation provided. However, I must say that varying a judgment or sitting as an appeal on the judgment of coordinate jurisdiction is different from a court enforcing its judgment or that of its brother judge. Again, Section 6, subsection 5 of the Constitution of this great nation, Nigeria, 1999, as amended hereinafter referred to as the Constitution, creates this court as a superior court of record for the purpose of completion and emphasis. Section 66A of the Constitution stipulates thus, and I quote, "The judicial powers vested in accordance with the foregoing provisions of this Section A shall extend notwithstanding anything to the contrary to all inherent powers and sanctions of the court of law," unquote. It is without doubt that one of the inherent attributes or powers of the court of law, as in this case, is its competence to enforce its judgment. This court is vested with judicial powers of the Federation under Section 6 of the Constitution. The apex court in the case of J.O. Anna Quincy versus Lewis Aneke and others, citation provided, Obaseki JSC of blessed memory held, and I quote, "Judicial powers of the Federation includes powers to enforce a decision or judgment or order given, and when Section 6, subsection 1 of 79 Constitution, that is the Constitution at that time, of the Federal Republic of Nigeria, which is in pari materia with Section 6 of the Constitution, vested the judicial powers of the Federation in the Court of Appeal, being one of the courts established for the Federation, vested in it that inherent power to execute its own judgments and orders. Section 287(3) of the Constitution mandates all authorities, persons, and courts to enforce the decisions of the National Industrial Court in any part of the Federation. The Constitution gives the President of this court the power to make rules that regulate practice and procedure, and the exercise of which the National Industrial Court Civil Procedure Rules 2017 was made. Order 49 of the rules of this court copiously captures the procedure for enforcement of judgment of this court. I am not unmindful of the position of learned counsel for the judgment creditors applicants in his written address in opposition to the counter affidavit of the judgment debtor respondent at paragraph 2.12 thereof at page 476 of the record, that the order of court directing the judgment debtor to file an affidavit disclosing the entitlement of the judgment creditor is in the interest of justice and in its inherent powers to make consequential orders. In response to the above position of counsel, learned counsel for the judgment debtor respondent in his final written address submitted that this court does not have the power to make such consequential orders, as it is only the court that handed down the judgment that has such powers. In resolving the contention between counsel as to the question thrown up by the judgment debtor, I will place reliance on the Court of Appeal decision in the case of Plateau State Board of Internal Revenue versus Mara, citation provides a 2020 decision of the Court of Appeal. In that case, the High Court of Plateau State declared in suit number PLD/J51/2008 that the appellant should pay to the respondent salaries and allowances pertaining to the Office of Director of Taxes from 23rd of October 2007 until its employment is validly or lawfully severed. The appellant did not appeal against this judgment. The respondent commenced another action to execute the said judgment in the National Industrial Court of Nigeria Jurisdiction because the appellant failed to pay the salaries and allowances as declared by the High Court of Plateau State, and he claimed specific sums that he believed represented the said salaries and allowances because the court merely said he was entitled. So the second action before the NICN JOS was commenced to claim those salaries, allowances, and fringe benefits declared in favor of the respondent, which amount was not stated in the earlier judgment of the Plateau State High Court. The NICN, before whom the action for execution was brought, found in the judgment that the declaration made in favor of the respondent in suit number PLD/J51/2008 still subsisted and was valid, and that the second action was for the implementation of the rights declared in favor of the respondent in that suit. The NICN found in the judgment that the respondent failed to lead credible evidence to prove that the sums claimed as his salaries and allowances as Director of Taxes of the appellant in line with the judgment. The NICN, however, went ahead to direct the appellant to calculate the rightful emolument due to the respondent as its Director of Taxes, bearing in mind the promotions he would have had, if any, from the 23rd of October 2007 to date or till the date his employment will have been statutorily severed by retirement, and to pay same over to the respondent, and that the appellant should do so within 1 month of the judgment. The Court of Appeal, when considering the issue formulated, stated those. So, okay, the issue formulated those, I quote, whether the lower court had jurisdiction to entertain the respondent's suit. 2, whether the learned trial judge was right in his judgment to have made an order on the appellant to calculate and pay the respondent emolument or entitlements as Director of Taxes and other financial benefits due to him, unquote. The court found that the second action before the NICN was clearly commenced to enforce the directives contained in the orders in the earlier judgment made in the respondent favor by the High Court of Plateau State in suit number PLD/J51/2008, and that the orders earlier made by the High Court of Plateau State merely declared the state of affairs of the employment of a respondent with the appellant and rights pertinent to the respondent from that state of affairs without an order for the enforcement of the right or how the rights are to be claimed or enjoyed by the respondent. The orders qualify as declaratory orders. The court further held that the action commenced by the respondent before the NICN was the contemplated, recognized, and sanctioned mode of enforcing compliance with the orders of the nature made in his favor by the High Court of Plateau State. The action was thus proper and did not constitute an abuse of the process of court. The Court of Appeal equally held that it was not out of place on this set of facts and circumstances of the NICN to have made the consequential order in question after having found that the respondent did not prove that the specific sums he claimed represented his salaries and allowances as declared by the High Court in that suit. The Court of Appeal found that consequential order given in the subsequent action before the NICN for parties to compute what the entitlements of the employee was only served to give effect to the declaration already made in favor of the respondent by the High Court in the earlier judgment, and which declaration the lower court found to still be subsisting and valid. To do otherwise will be to leave the respondent with a declaration of a right that has no remedy. The Court of Appeal rationalized its decision on the fact that the law is an equal dispenser of justice and leaves none without a remedy for his right. And wherever there is a wrong, there ought to be a remedy to redress that wrong as laid down in the following cases: Lau and PDP citation captured, Oyekomi and NEPA citation provided, First Bank of Nigeria PLC versus Associated Motors Company Limited citation captured. According to the Court of Appeal, the above is the essence of a mazim ubiju bi remedium, meaning where there is a right, there is a remedy. It is clear from the decision of the Court of Appeal in Plateau State Board of Internal Revenue and Mara Supra that in the enforcement of a decision of the court enforcing the decision can make consequential orders with a view to doing substantial justice, and that will not be out of jurisdiction for the enforcing court to do. It is noteworthy that the extant rules of the court, particularly Order 49, Rule 6, Sub-Rule 3, stipulates thus, and I quote, the court, on hearing the application, that is application for execution or any other application that has to do with post-judgment, the court, on hearing the application, may grant leave in accordance with the application or may order that any issue or question, a decision on which is necessary to determine the rights of parties, be tried in any manner in which any question of fact or law arising in an action may be tried, and in either case may impose such terms as to cost or otherwise as it thinks just, unquote. It is clear from the above provision of our rules, which regulates the execution of judgment in this court, that this court, upon hearing the application for leave to execute, is empowered to order that any issue or question, a decision on which is necessary to determine the rights of parties, be tried in any manner in which any question of fact or law arising in an action may be tried. In the instant case, there were uncertainties as to the actual amount due to the judgment creditors, since the court in its judgment merely declared that they are entitled to be paid their terminal and redundancy benefits without specifying the amount, so it was not out of place for court to order that same be clarified by the judgment debtor, who was the employer. The order of this court that the judgment debtor should clarify the entitlements of the judgment creditors pursuant to the judgment is suit number NICN/KN/5/2012, which merely declared the rights of the judgment creditors to terminal benefits and redundancy allowances without stating any specific sum, is thus in order. Because actually in that judgment, the court ordered that the judgment debtor should calculate the amount due to all the judgment creditors and pay them. It is unfathomable that this court, being one of superior courts of record in the Constitution, will have no vows and be unable to enforce its judgments and orders, and that enforcing such judgment will amount to reviewing the judgment. Accordingly, issue 2 is also resolved against the judgment debtor respondent. As per issue 3, the judgment creditors applicants brought this action to enforce the judgment of this court handed down since 2015, as I've said, which is still valid and subsisting to claim as the entitlement as declared by that judgment. This court, pursuant to its inherent powers, ordered parties to provide evidence of entitlement of the judgment creditors applicants, to which the judgment creditors complied with, and placed before the court their calculations of their entitlements in the sum of 44,061,423 naira 79 kobo. The court also ordered that parties should furnish it with evidence of indebtedness of the judgment creditors, since the judgment debtor by the said judgment are also creditors by way of loan to the judgment creditors, and which evidence should be in line with the judgment. The judgment debtor on its own side, after much resistance, responded, though it is not contending, that the facts put forward by the judgment creditors, that the judgment creditors are indebted to it by way of the loan interest and deductions in the sum of 329,025 kobo, particularly first judgment creditor and Mustafa Muhammad Mahmoud and one Lucy Umar Abba. See pages 493 and 513 of the record. The judgment creditors on their own part denied being indebted to the judgment debtor in the said sum, as the 3 judgment creditors referred to have all discharged their liabilities under the loan. I perused the affidavit of facts deposed to by both parties, and I find that there is no dispute between parties as to the entitlements of the judgment creditors pursuant to the judgment of this court. As admitted by the judgment debtor respondent, it is indebted to the judgment creditors applicants in the sum of 44,961,423 naira 79 kobo. However, one area of dispute between parties is the issue of the actual indebtedness of the judgment creditors in respect of the status car loan given to them while in the employment of the judgment debtor. According to the judgment debtor, only 3 of the judgment creditors are indebted to it, and which indebtedness the judgment creditors are refuting, be it their affidavit. The judgment of this court in suit number NICN/KN/5/2012 specifically declared that any past portions of the loan granted any of the claimants remaining unpaid must be paid back in accordance with original terms of contract, shun any penalty clause that increases the interest rate as a result of the disengagement. I painstakingly perused the documents relied on by both parties in proof of each side's assertion, and juxtapose same with the order of the court in the judgment sought to be enforced. It is clear thus that at the said resignation of the appointment, the first judgment creditor had a total indebtedness of 2,395,815 naira, accumulated sum of the loan sum allowances already paid, and which sum was to be charged thereafter at 18% interest rate. It is worthy of note that the above sum of 2,395,815 naira includes the car loan balance and some upfront allowances which the court had ordered in its judgment that the judgment debtor had no power to charge as indebtedness. The court in the said judgment held that the judgment creditors are only indebted as per the loan balance, and that the upfront allowances already paid, which were added to the indebtedness of judgment creditors, is nullified, leaving only the loan balance. Just a minute. By the judgment of the first, by that judgment, the first creditor is only indebted in the sum of the car loan balance alone, which, as at September 2010, was the sum of 1,770,638 naira 20 kobo, as per the annexure to the said letter. As such, by the judgment of the court, the first judgment creditor was only indebted as per the loan sum. Again, the second, the 18% interest rate, which the judgment debtor started charging the first judgment creditor, as seen from its letter to the first judgment creditor dated September 14, 2010, after the resignation, was the penalty interest rate, which the court ordered against, and thus ordered that the loan should continue to be charged as the original interest rate according to contract. Thus, the 18% interest could not stand in the light of the court's judgment. I'm mindful of the documents relied on by the judgment debtor in proof of its assertion that the 3 judgment creditors are indebted to it in the total sum of 125,387,025 kobo. I find therein, especially from the statement of accounts, that the sum which the judgment debtor is claiming as the total indebtedness of the 3 judgment creditors still included the allowances which the court knocked off in its judgment. I say so in view of the fact that from the statement of account of the first judgment creditor, one will see from the opening debit on the 21st of February 2011 that the said sum included the said allowances which were knocked off from the indebtedness of the judgment creditors by the court in its judgment. From the day the court delivered its judgment in 2015, the judgment creditors stopped being indebted in the remainder of the upfront allowances. Their indebtedness is only as to the loan sum. The said document as put forward by the judgment creditors, which still included the upfront allowances contrary to the said judgments as put forward by the judgment debtor, which still included the upfront allowances contrary to the judgment which is sought to be enforced, can thus not be relied on by this court. Also, the judgment debtor has not shown this court the interest rate it was charging because the order of court was specific that the loan sum should be charged at the original terms of the contract. At any rate, none of the documents put forward by parties captured the loan sum only, and at the interest rate chargeable as ordered by the court. It is therefore clear that the court cannot rely on any of the documents put forward by parties as they are not reflective of the judgment of court as per the loan indebtedness. It is, however, worthy of note that the above unclear indebtedness as to the loan sum is in respect of a counterclaim of the judgment debtor respondent in the said judgment sought to be enforced. In any case, it is not even all the judgment creditors that are said to still be indebted to the judgment debtor by way of loan, which means that the indebtedness does not even concern 6 of the judgment creditors who equally have a right to the judgment debt of 44,961,423 naira 79 kobo, already admitted by the judgment debtor. In fact, counsel on behalf of the judgment debtor, Sir P.O. Aihohai, Esquire, has personally undertook to prevail on the judgment debtor to pay the entitlement of the unaffected judgment creditors. Besides, it is limpid from the order of court in the judgment that the court did not even order set off of the indebtedness of both parties. Put in other words, and more pungently, each of the parties could take steps to enforce the part of the judgment that favors each of them, since there was no order of set-off. There's nothing stopping the judgment debtor from seeking to enforce the loan sum as directed by the judgment whenever it is ready to do so. Be that as it may, the subject of this enforcement is on the entitlement of the judgment creditors under the main claim in the judgment. I say so in view of the fact that it was the judgment creditors that brought this application to enforce the part of the judgment which dealt with their entitlement. The judgment debtor has not brought an action to enforce the part of the judgment that dealt with its counterclaim, wherein the court ordered that the judgment creditors are indebted to it only in the loan sum. The parties are addendum as to the fact that the judgment debtor is indebted to the judgment creditors in the sum of 44,961,423 naira 79 kobo, as I've stated severally here under the main claim. It is in my view that since the judgment debtor has admitted the above sum, judgment could be executed on the above sum. I'm equally mindful of the fact that although there is nothing to show that an appeal has been entered against the judgment of this court, which means it is valid and subsisting, there are pending applications before the Court of Appeal and ordering that the judgment debtor pays the above admitted sum to the judgment creditor may end up foisting a situation of fait accompli on the Court of Appeal if eventually the appeal is entered. I've equally mulled over the fact that since the judgment of court is still valid and subsisting, the judgment creditor is entitled to the fruit of his judgment, and the court ought not to allow the antics of the judgment debtor to deny the judgment creditors such as reason supra. I also consider the fact that the appeal, if it was ever entered and heard, would go in favor of either parties, in which case the judgment debtor, who is equally a bank, will have utilized the judgment sum to its advantage if left in its custody. In fact, it is so obvious that the judgment debtor at each stage is realizing the judgment, at each stage it realizes that the judgment creditors are about to execute the judgment, will take steps on appeal, albeit wrongly, to frustrate the said proposed execution, and will then go back to sleep. There's no doubt that the judgment debtor is only deploying the judicial process mala fide in order to deprive the judgment creditors the fruit of their judgment through the process of appeal, which I do not think it wishes to pursue from the circumstances and all facts before this court. At this stage, I recall the saying that justice is not a one-sided game. Justice is usually not a one-way traffic, perhaps a three-way traffic. See the case of Akwa, Diaha, and Uko citation captured. It is the respectful view of this court that the interest of justice will be best served to both parties and also preserve the rest pending the determination of the appeal, if any was ever entered. If this court orders that the judgment debtor pays the admitted indebted sum of 44 naira 61,423 naira 79 kobo into the custody of a third party, pending the determination of the appeal, if any. Admittedly, the contingency on which the conditional order is predicated is the determination of the appeal, if any. I'm repeating that word, if any. So the said order of this court will in any event abate and become spent by operation of law upon the delivery of the judgment on appeal, or if there was no appeal at all, in the event that the Court of Appeal does not exercise its discretion to enlarge time in favor of the judgment debtor. Also, if the said judgment is set aside, the order of this court for the conditional execution of the judgment will also be set aside. So any of the parties favored by the judgment will have unhindered access to the sum. Therefore, none of the parties will be prejudiced. Consequent upon this, it is hereby ordered that the judgment debtor, that is Unity Bank, within 7 days from this order, pay the sum of 44,961,423 naira 79 kobo by issuance of a check in the name of the Chief Registrar of the National Industrial Court of Nigeria, who is to deposit same into an interest-yielding account, pending when the appeal may be entered. I am very careful of the choice of my words. May be entered and determined, if at all, by the Court of Appeal. Ruling is accordingly entered. So that is the ruling of this court.
Thank your Lordship for a very well considered ruling. And may God bless your Lordship.
Amen. Thank you.
Thank you, my Lord, for a well-considered ruling.
Very well. Copies of this will be available Monday. You can pick it up. From the court. I rise.